Just 1 minute, sir. Just. ಧ್ವಜವಂದನೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ರಾಷ್ಟ್ರ ಧ್ವಜಕ್ಕೆ ವಂದನೆ ಸಲ್ಲಿಸಲು ಇಲ್ಲಿ ನಿಂತಿದ್ದೇವೆ. ಅದರ ಗೌರವ ಮತ್ತು ವೈಭವವೇ ನಮ್ಮ ಬೆಳಕು ಮತ್ತು ಶಕ್ತಿ ಮತ್ತು ಅದರ ಪಥವೇ ನಮ್ಮ ಪಥವು. ಈ ರಾಷ್ಟ್ರೀಯ ಸಂಸ್ಥೆಯ ಮಾನ್ಯತೆ ಪಡೆದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅರಿಯುವ ಮೂಲಕ ಅದಕ್ಕೆ ನಮ್ಮ ನಿಷ್ಠೆಯನ್ನು ತೋರಿಸುವ ಪ್ರತಿಜ್ಞೆ ಮಾಡುತ್ತಿದ್ದೇವೆ. ದೇಶ ಸಮೂಹಗಳ ನಡುವೆ ನಮ್ಮ ರಾಷ್ಟ್ರ ಧ್ವಜವು ಉನ್ನತ ಮಟ್ಟದಲ್ಲಿ ಹಾರಾಡುವ ಸಲುವಾಗಿ ನಮ್ಮ ಅಧಿಕಾರದಲ್ಲಿರುವ ಎಲ್ಲವನ್ನೂ ಅದಕ್ಕೆ ಸಮರ್ಪಿಸುವ ಪ್ರಮಾಣ ಮಾಡುತ್ತಿದ್ದೇವೆ. ಜೈ ಹಿಂದ್. IMA ಚಿರಾಯುವಾಗಿರಲಿ. ವಂದನೆಗಳು. Thank you, sir.
Yes, sir. Thank you very much, sir. And a warm good evening to all. Before I request our State President, Dr. Chinivalar, to have few words on the topic and today's talk. Respected IMA KSB President and distinguished colleagues, it gives me a great pleasure to introduce today's talk on a subject of immense relevance to our daily clinical practice, that is medical certificate, ethical and legal issues. In our role as medical professionals, definitely we are all frequently called upon to issue various medical certificates. It can be for sickness, fitness, disability, medical leave, insurance, medical legal purpose, or court-related matters. While this may look very routine to all of us, but every certificate we issue carries with it a significance related to ethical responsibility and also legal implications. Today's talk will help us to reflect on the legal framework surrounding our medical certificate that we issue and what constitutes a valid certificate and how to avoid common mistakes and malpractice traps, and also how to safeguard both patient interest and also professional integrity. And before I introduce our renowned speaker, Dr. Suresh Badamat, I request our State President, Dr. Veerabhadrappa V. Chinivalar, to have introductory words to the audience.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಇಂದಿನ KPPS ಮುಖಾಂತರ ಆಯೋಜಿಸಿದಂತಹ ಇಂದಿನ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಥಿಕ್ಸ್ ಆ್ಯಂಡ್ ಲೀಗಲ್ ಲಯಬಿಲಿಟೀಸ್ ಅಂಥೇಳಿ ಒಂದು ಒಳ್ಳೆಯ ಟಾಪಿಕ್ಕನ್ನು ಆರಿಸಿಕೊಂಡಿದ್ದಾರೆ. ಇದೇ ನಾವು 1980ರಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದಾಗ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಂತಲ್ಲ ಯಾರು ಬಂದು ಕೇಳಿದ್ರು ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಬರೆದು ಕೊಟ್ಟು ಕಳಿಸ್ಬಿಡ್ತಿದ್ವಿ ಅವಾಗ. ಯಾಕಂದ್ರೆ ಅದ್ರಾಗ ಅಷ್ಟು ಜಾಸ್ತಿ ಇಂಪಾರ್ಟೆನ್ಸ್ ಅನ್ನಂತನಾಗಲಿ ಏನಾಗಲಿ, ಕೆಲವು ಸಲ ಕೋರ್ಟ್ನಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಅದೇ ಹೋಗಿ ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋಗ್ರಿ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ತೊಗೊಂಬರ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. ಸೊ ಕೊಟ್ಟು ಕಳಿಸ್ತಾ ಇದ್ವಿ ಅವಾಗ. ಆದರೆ ಇತ್ತೀಚೆಗೆ ಅದರ ಏನಂತ ಇಂಪಾರ್ಟೆನ್ಸ್ ಇಸ್ ವೆರಿ ಮಚ್ ದಿಸ್ ಒನ್. ಸೊ ಅದರ ಬಗ್ಗೆ ಒಂದು ವಿಸ್ತಾರವಾಗಿ ಆಗಲಿ ಇದಾಗಲಿ ಕೂಲಂಕಷವಾಗಿ ಚರ್ಚಿಸೋ ಸಲುವಾಗಿ ನಮ್ಮ ಡಾಕ್ಟರ್ ಮಧುಸೂದನ್ ಕಾರಿನವರು ಒಂದು ಒಳ್ಳೆಯ ಟಾಪಿಕ್ಕನ್ನು ಆರಿಸಿಕೊಂಡು ಸೊ ಒಳ್ಳೆಯ ಡಾಕ್ಟರ್ ಸುರೇಶ್ ಬಡಮಠ ಅವರ ಮೂಲಕ ನಮಗೆ ಒಂದು ಒಳ್ಳೆಯ ಇದನ್ನು ಜ್ಞಾನವನ್ನು ನಾಲೆಜನ್ನು ಕೊಡಿಸ್ತಾರಂತ ಹೇಳಿ ನಾನು ಕೇಳಿಕೊಂಡು ಈ ಮುಂದಿನ ಒಂದು ಕಾರ್ಯಕ್ರಮ ಸಾಗಲಿ ಅಂತ ಹೇಳಿ ನಾನು ಕೇಳಿಕೊಳ್ತಿದ್ದೆ.
ಧನ್ಯವಾದಗಳು ಸರ್. And Dr. Suresh Badamat is a very well-known figure among our medical fraternity, especially in the medical legal field. And it gives me a very immense pleasure to introduce our today's speaker, Dr. Suresh Badamat, who is a professor of psychiatry at NIMHANS, which is our country's foremost authorities in medical, legal, psychiatry and health issues. And Dr. Suresh Badamat has got MD and DNB in psychiatry from NIMHANS. And he holds PG diploma in medical law and ethics and PG diploma in human rights and law. And also he holds a PhD in mental health legislation from NLSIU Bangalore. And he is presently the professor of psychiatry, head and forensic psychiatry unit at NIMHANS, and also heads the telemedicine center and head adult psychiatry, the unit 5 at NIMHANS. And also he is an officer in charge of NIMHANS Digital Academy. And definitely to introduce him, it needs a seminar. It's a topic of seminar about his introduction. However, I want to be very, restricting myself to his main achievements. And he has authored more than 400 scientific articles and edited nearly 15 books. And he is recognized in authority in forensic psychiatry, obsessive compulsive disorder, telepsychiatry, medical law and ethics, community psychiatry, and mental health policy. He spearheaded the mental health programs at district and national levels in India. And he actively shares knowledge via his YouTube channel, and more than 550 videos he has got it is credit, which aimed at professionals in mental health and medical legal practice. And he has got various accolades to his credit. The mainly among them are Sir C.V. Raman Young Scientist Award and Professor Raghuram Young Teacher Award. Here is Dr. Suresh Badaman, who is a distinguished psychiatrist, medical legal expert from NIMHANS with deep academic credentials, a profile research record, and a strong commitment to education and community service. With extensive experience in forensic psychiatry, medical law, and public mental health, he brings a wealth to insight into our topic. Now, I invite you all to listen to his talk carefully, interact freely, and most importantly, carry forward the key messages into your daily practice. Thank you, sir. Here is Dr. Suresh Madamu to you.
Thank you, Madhusudan sir. Thank you, the President. Today we have a participants from Gujarat, Maharashtra, Gujarat National Law School University students are here. And of course, Karnataka MA participants are here. So in this regard, today we'll be discussing about the medical certificate from the perspective of law and how it will be taken into perspective. I have planned this presentation for exactly around 35 to 36 minutes. Hope I'll be able to finish within that 35 to 36 minutes. And we will spend somewhere another maybe 15 to 20 minutes with regard to question and answer session. So this is the QR code where you can find the videos which have been in medical law ethics. If you are doing PGDMLE from National Law School, Bangalore or Gujarat, you will find all the videos with regard to medical law ethics. So this is the QR code. So today I'll be in next 30 to 35 minutes, I'll be covering on these headings: case vignettes, what is medical certificate, different types, what is the content and the format, what is the general principles and how to issue medical certificate, process of certification, drafting, documenting, and issuing medical certificate. So this is how we'll be presenting. Let's start with the case vignette. The simple reason is, if I give you theoretical information, you'll not be able to appreciate it. Let's discuss a case which I have changed a little bit. Here is a Dr. P, a senior physician, almost 67 years or 68 years now. He's highly respected physician with 35 years of practice in Mumbai. Was invited to home visit because a senior person, Mr. X, a 94-year-old eminent film producer known for delivering multiple hit movies, had some issues. Hence, Dr. P was invited. So given the Mr. X stature in the Bollywood, Dr. P felt honored and agreed to go to the home visit. During the consultation in the home, which lasted for around 60 to 90 minutes, Dr. P interacted with Mr. X. During this, he observed some clinical observation. There was some mild hypertension and mild BP. And also he found that he had some cognitive deficits. Cognitive deficits means memory decline was there, unable to concentrate for longer duration. Sometimes he was getting confused, poor attention span, concentration was difficulty. Since he was 94 years old, he had hard of hearing also. The doctor has to ask the same question 3-4 times. And also there was noticeable memory lapse was there. So Dr. P finally, at the end of 60 to 90 minutes, he prescribed medication and advised the family to undergo some diagnostic investigations, neuroimaging and laboratory workup. So these were the 1.5 hour interaction with the Mr. X, who is a producer, and also the findings. The family did not stop here. They said, sir, he is already 94. His checks are getting bounced. His signature is not being identified by the bank. Can you issue a certificate? The doctor was very happy. So the Dr. P issued a certificate telling that Mr. X was not fit for handling bank account. And it can be joint account or the thumb signature can be taken. So Dr. P issued a certificate then and there only declaring he is unfit to manage his bank account. And Doctor was so happy to see this renowned person. He did not even charge even a single pie. He did a free visit and also gave a certification also. A few months later, Mr. X passed away because of various ill health. And then after 2 to 3 years down the line, there was a summons from the court to testify for an ongoing legal dispute with regard to Mr. X family members regarding the concern of assets worth 180 crore. And one of the family member, that is his son, was contesting that Dr. P had given a certificate and whatever the will written by Mr. X is not valid and I should get this amount. The court directed the Dr. P to submit all the relevant medical records pertaining to examination of Mr. X, including the true copy of the certificate issued. The Dr. P faced a serious challenge because he neither recorded anything about Mr. X in his OPD or in his register or in the hospital. Because it was a home visit, neither he preserved the medical certificate what he had issued. There was no documentation available and he did not knew on the what day he had examined around 3 years back. And this was an issue which he had faced. I will take this case later in the end if there are questions. This is how our doctors want to help people and get into trouble where he is not registered anything. So now with this case vignette as in the background, as our IMA President of Karnataka said, earlier we used to issue certificates, very right, left, center and right. But now whenever we issue certificate, it can become a legal issue at any time. So what is medical certificate? It is a written professional opinion from a doctor regarding the patient's medical examination, diagnosis, treatment and recommendation. Specifically, examination, diagnosis, treatment and recommendation. It is a legal document, can be challenged in the court of law. Along with this, medical certificate is very personal to the patient. It is very sensitive, highly confidential document. And there is a process. One is certificate. Medical certificate is a piece of document. But there is a process of issuing the certificate called as certification. Medical certification is a process of issuing a medical certificate by an authorized medical practitioner. What is the certification process? It consists of receiving the request, accepting the request, knowing the timeline, within how many days I have to issue the certificate, what are the assessments, what are the investigation, how to achieve the diagnosis, observation, drafting and issuing a certificate. So it's not a piece of paper, it is a process of issuing the certificate. So where do we get this power of issuing the certificate? It comes from the National Medical Commission Act 2019, Section 34 says clearly, no person other than a person who is enrolled in state register or national register will issue the certificate. And also, he can give evidence in the court of law. That is Section 34, subsection C and D. One is entitled to give a certificate of fitness or disability or maybe ability. At the same time, to provide evidence in the court of law. So this is the power given by the National Medical Commission Act 2019. Now let's understand, we understood the definition. We understood under which law the power is given. Now let's look into the different types of certificate. There are two types. This is the classification which we have done in NIMANS. One is procedural based certificate. That is by the virtue of executing certain process or a procedure under the law, you have mandated to give this. One is legislation based, like Transplantation of Human Organ Act, that is TOA Act, MTP, Medical Termination of Pregnancy, Mental Health Care Act, Right to Persons with Disability Act. These acts mandates the doctors to issue some certificate. or even death certificate also comes into picture here. Birth certificate. Similarly, forensic based, it may be criminal, civil, criminal cases, maybe injury, those kind of things. Civil cases, which I just now discussed about the testamentary capacity. Executive decision. Executive decision is fitness to join a job, fitness for studies. So these are all procedural based. At the same time, on request, the patient is requesting for sickness related, I am sick, give me certificate, or dysfunction, I am not able to do driver's job because I have narcolepsy, I can't drive the vehicle and I go into sleep very fast, or dysfunction. Functionality, I am now fit to join the job, functionality job. So these are the two grossly defined certification process. Again, procedural based. The list has been given in the National Medical Commission or Indian Medical Council, the Professional Conduct, Etiquettes and Ethics Regulation 2002. It lists which are the legislation. These are the list of legislation under which the doctor is supposed to give the certificate. Invariably, this is the 2002 list. But nowadays there are many acts have come into picture. You can take Transplantation of Human Organ Act. It was again a old, but again ART Act is there. That is Artificial Reproduction Act is there. Surrogacy Act is there. RPWD Act. All these acts also mandates the doctors to give certificates. Procedural based, I have told you, this is criminal case, maybe post-mortem report, murder, violence, civil cases, testamentary capacity, impotence related, medical insurance related civil cases, executive decision, I told you. So coming to on request, we will already have discussed sickness related dysfunction and functionality. Invariably, my teacher used to tell me, the doctors are known to examine a person who is sick, not the examine who is normal. So we don't issue normalcy certificate. This was the norm earlier when I did my MD in 1998, when I finished my MD at that time. So 2001, I finished my MD. At that time, they used to say, we don't issue normalcy certificate. But now, instead of normalcy, we say absence of illness certificate. What is that absence of illness? No, he doesn't suffer from any illness. Rather than saying normal, because the definition of normalcy is very difficult to define. So sickness certificate, dysfunction or functionality. Functionality is fit to do this job. Now understand about the moving to the next topic, content format of medical certificate. Again, the Medical Council of India has given the format. This is the minimum format you need to follow. You can add on, but you can't delete some of the requirement what it says. This 1.3.3 talks about you need to adhere to this minimum format which you need to issue when you're issuing, but you can add something else. Instead of signature, nowadays you can ask for Aadhaar card, photo ID card you can ask, but you need to have that. Earlier it was only you need to have black mole or maybe identification mark was there. Now you can modify. So this is the latest 16/4/2013. The Medical Council said that the format should be in this way. Signature of the patient or thumb impression, it was there earlier. Now we can modify it to other number if he is able to give, and if are able to validate, yes, the photograph of the person and the same person is here, or else identification marks you can bring in, doctor so and so, all those things. But requirement can be added more here, like my observation ABCD have been found. Logical explanation can be added into the certificate, but this is the minimum you need to have the information in the certificate. So signature I showed you, and this is the signature of the medical attendant. This is the content, identification mark, I, Dr. So-and-so, carefully examination of the person so-and-so, hereby, whose signature is given, who is above, is suffering from so-and-so illness, and with effect it's absolutely whatever restoration, he needs to have this certificate. So the MCI and NMC requirement is the nature and the probable duration of illness should be specified. The certificate must be accompanied by a brief resume of the case. What is the summary of the case? And please remember, keep a copy of the certified certificate. You have issued a certificate to the patient, a copy should be retained with you. When you are issuing the certificate, take a signature of the patient. Invariably, it should be the patient, not somebody else. Unless you are able to prove the patient was not capacitated or the patient did not have the mental capacity or he was not fit, he was unconscious, then only you have to take the signature of somebody else. Otherwise, by default, it is the patient who has to sign the certificate. It can be discharge summary, anything, because by law, the default is everybody is fit, everybody is sane, everybody has capacity to give consent. So you need to take consent to issue certificate from the patient only, unless the otherwise is proved. Like death certificate is no more, so the guardian will take the certificate. So then who is the guardian? The guardian, whoever brings the death certificate and is able to establish the relationship with the person who has demised. So, but important thing is you have to keep the copy of the certificate. So invariably, this is how the current requirement, what we have done in the recent amendment of NMC, and all these have been done, but anyhow, that regulations has been kept in the abeyance at this point of time. It may be notified again after some time. Till now, we have discussed about content. The important part is the process of certification. This is the place where majority of our doctors make mistake. So I request all of you to give attention now at this point of time, how to process. First and the foremost, somebody comes to you seeking certificate. That is the application phase or an inquiry phase. The patient is, or the patient family member has come to you, they're requesting. Once they request, you need to determine whether should I accept, whether imagine if I am a psychiatrist and they're asking for orthopedic certificate, you should reject it. I am not the right person. To determine whether I am eligible to give or not, that is the determination phase. Assessment phase. I have accepted. Now you have to do the assessment. During the assessment, you may have to observe the person. You need to document what are your findings. And finally, you need to decide whether he is fit, whether he is unfit, whether he should get leave, whether he should come for reassessment. That is the decision you take, and you need the draft the certificate. And finally, you need to issue. Whom to issue? And finally, sometimes you may have to transport the certificate to the court, or maybe to the employee. It may be bank, or maybe it may be to the police custody. So who is going to transmit this certificate? So you need to understand this 8 step. One of the step goes wrong, invariably you get into trouble. So if you are able to follow this process of certification, invariably you don't get into trouble. Let's understand about the inquiry phase. Who is requesting the certificate? What is the purpose of certificate? Whether it is a new case or an old case. Imagine Dr. Madhusudan Karignur is treating somebody since past 8 years. He is an old case. He has a good medical records. He knows the family very well. He can issue the certificate then and there. Suppose if it is a new case, first time they are coming in front of Dr. Madhusudan. You do not have any records. First time they're registering. Now he needs to know how much time he has. Invariably, the people who come for requesting medical certificate, they will come on horse. Horse means they will come on the, like, sir, I want certificate now. If I don't give by evening, I will not get a seat. I will not get this. I will not get the job. So don't fall for the trap. If they are somebody so hurry-burry or who requires certificate within 1 hour, 2 hours, you may request them to go somewhere else. Don't ever fall for the trap. If you fall, then you need to face the music. Whom should we address this certificate? Is there any medical legal issue involved? Whether the same person will carry the certificate or should I post it? And what is your role in this certificate? You need to understand. Now, determination. Determination means, should I give the certificate? Is it a valid request? Whether there is a patient available or not, or somebody else is requesting on somebody else's behalf. Check whether he says, I am the patient. Imagine, I'll go in front of Dr. Maybe Madhusudan or maybe Pawan Patil. I go to Dr. Pawan Patil and say, I am Dr. Madhusudan. Instead of telling myself Dr. Suresh, I'll say Dr. Madhusudan. Now, Dr. Pawan Patil in Haribari issues a certificate to me telling that I am Mr. Madhu. So you need to know the verification ID of that person. So proper documentation of the request. Is it a old case, new case, doctor related? Whether you have treated to him or not, the first time you are treating, you have to be very careful. So you need to accept that I'll be issuing today, or you may say that I would like to do this assessment. It will take 1 week, or it may take 2 weeks, or it may be 3 days. You need to do investigations, or you need to reject. Assessment phase, it is based upon your clinical professional discretion. Some doctors, if there is a lot of medical legal issues are there, they may say, I want the certificate is for the purpose of doing a testamentary capacity, is going to execute a will. Then you need to decide whether I would like to issue the certificate on outpatient or inpatient, whether you would like to do a detailed thorough evaluation, collect all information possible, treatment in the past, investigations if you want to do general physical examination, mental status examination, and of course any other investigation you want to do. Observation phase, suppose you want to admit the person and observe him, especially court related matters. It can be impotence test, or it can be maybe various other purposes, like suppose examination of a accused with regard to rape, or it may be even the examination of the survivor of sexual assault. So you need to admit and examine whether there was a cooperation, whether the person was able to give consent. If he is refusing consent, how many efforts you did to take the consent. Should you force on him to do the examination? So those are the things you need to take a decision. And whether there was any extra behavior, less behavior, whether he was intoxicated, all those information and ward observation need to be documented. Finally, you need to documentation. What are those documentation? Please document thoroughly in your own handwriting if possible. File all the investigation, serial observations on day-to-day basis, summarize your findings, especially with regard to court. Whenever you are submitting the certificate to the court, summarize the findings, logically explain your findings. That is very essential, because invariably after 5 years, 6 years, the court will call you, and what you are thinking around 5 years back, you may not be able to recall. If you have written the logical explanation, why I have arrived to this diagnosis, why I am giving this disability certificate or ability certificate, what was my thinking? If you are able to logically write it, you will be able to explain the court, and the court will be happy to accept that logical explanation and the decision taken. How? Finally, the decision of drafting and giving. Draft the certificate. If you don't know how to draft the certificate, take help from the seniors. That is the best, because the seniors will have amazing wisdom. Talk to them. Is there, check with the patient or the patient party, is there any format? For example, recently there was an issue occurred where in one of the government, semi-government, if the father dies, the job will be given to son. Then the doctor had given a certificate, but that semi-government or the society refused to accept because it is not in the format what they required. So whether there is a preformed format is there, how many number of copies to be given, whom to be addressed, or should we hand over to the person? Date, time, and signature, very essential. If you don't date the validity of the certificate, we do not know. When did you examine and the time? That is very essential, because imagine you have examined somewhere maybe in January, and the certificate is produced in the court of law maybe after 3 years down the line. You should be able to say that I have examined on January 31st, 3 o'clock in my OPD or inpatient. This is the records. So you are able to tell the timeline and your assessment at that time. After 3 years, the patient would have deteriorated, or the patient after 3 years would have multiple strokes, or he may be improved completely. So for that reason, the timeline becomes very essential. Issuing, whom to issue the certificate. Many a time, if you are a private practitioner, you will be issuing. In many of the medical colleges, in a district hospital, they say it has to go through the HOD, or somebody may say it has to go through RMO. This is the internal understanding. Why, sir, internal understanding? Imagine our doctor is there, maybe Dr. Pawan Patil, I can tell you, he is HOD of one of the medical college. Imagine his junior resident issues a certificate. After passing the exam, he has gone. After 5 years down the line, the HOD receives a summons. Now, by ex officio HOD, what the GR is given, junior resident has given, he doesn't know. So invariably, these medical colleges, district hospitals, in district hospitals, the doctor get transferred. So the virtue of somebody being in that position may have to go to the court telling that, sir, I have not examined, but in his place, I have become the HOD, or I am the head of the unit. I have not examined, but I can explain the court what the doctor has written. Otherwise, the doctor is already retired or is no more, those explanation can be given. So executive decision within the department would have been taken that junior resident will not issue or the senior resident will not issue. Only the permanent faculty or the permanent person will issue the certificate. That is the internal matter within the executive order. Is it right? Yes, it is right for the purpose of within the department to work. No, sir, the NMC gives permission to issue to anybody. Of course, it can be doable. Any registered medical practitioner within the area of his training and the capacity, he can issue. But he needs to be available for to testify in the court of law. Hence, that authorization, whether he is able to do it or not, from the executive order, you should be able to understand. So this is how the issuing the certificate occurs. And you need to know what is the internal mechanism in the medical college. It may change from medical college to college. Who is transporting the certificate? Is it the patient, or you are going to send an email, or you are taking the photograph and send it through WhatsApp? Make sure that it is not leaked into the social media, or else you have to sign it and post it to the court. The court is invariably, when you are sending to the court, this is one of the thing which the judge said. If you are referring to the court, name the court, and in the top of the letter you have to say confidential. The judge will open, nobody else will open. If it is written confidential, to the court. If you don't write confidential, a clerk or somebody else will open in the court, because in Bangalore there are 52 to 70 courts are there in one civil complex, and it will go to one of the court, and that court person will. If you write specifically to the court, don't write the name of the judge. It's not a personal letter. You have to write to the court, maybe Chief Judicial Magistrate 52. If you write and then write confidential, it will only the judge who is concerned to that court only will open. That confidential word matters a lot. So that is very essential. This is recently I came to know. Please write the confidentiality. Otherwise, it will go and fall somewhere else. Don't send it through email unless you are very particular. You know that this person, this email belongs to somebody. So then only you do it, and don't transmit the certificate through social media. Avoid it. But still nowadays, people do transmit. If you are clear about that, you can do, but take your own risk. Now coming to the last part of the ethical and legal issues in certificate. Suppose if you are issuing a false certificate, under regulation 7.7, it clearly says that any registered medical practitioner who is shown to have signed or given under his name and authority any such certificate, reports, documents of similar character which is untrue, he is liable to be punished by his name can be removed from the register. So don't give false certificate. We have seen in many places they sell the certificate at 25 rupees, 30 rupees. Don't do that. Something goes wrong, you are liable for your name to be removed from license to practice. So false, fake certificate, don't do tampering, don't do the omission or commission mistakes in the certificate. If you look at the Bharati Nyaya Samhita, earlier Indian Penal Code 197, currently 234, also dictates for issuing a false certificate. There was a case which has occurred in our Bangalore Medical College where the certificate was issued by one of the doctor for a big scam, where he was caught and his name was removed. He was given 2 years imprisonment. So that should not happen. Similarly, it talks about issuing a true certificate, but he knows that it is false. It is a bailable and non-cognizable offense. Please don't do that. Or else, if he is a government servant, Prevention of Corruption Act of 1988 can be pressed. Respective legislation dictates also is there. Like suppose RPWD Act is there. Issuing a false certificate, you can be punishable. Mental Health Care Act is there, which again, if you issue a false certificate, you will be punishable. If you are issuing a certificate under Toha Act, especially for brain death, you have to follow the procedure. If you violate those laws, you will be punishable. Coming to the evidence in the court of law. Certificate has to be produced in the court, and that has to be testified or cross-verified in the court. Like suppose I have issued a certificate, it will go to the court. In the court, the cross-examination occurs, and I have to accept, yes, this is my certificate, I have signed it, and it has to withstand the scrutiny of the cross-examination. Then it becomes the evidence. Till now, I talked about this. Now, these are the last part of my presentation, tips for all the doctors when you are issuing the certificate. Issue the medical certificate only if you have examined the patient. Don't issue to the certificate you are not examined. Never do that. Sir, my senior has seen the patient. Like imagine Shumaga Medical College is there. The HOD has changed now. The earlier HOD used to see a patient for maybe asthma for since past 2 years. That HOD is not there, but the new HOD can issue the certificate by the virtue of being in that post ex officio. Otherwise, don't issue. If you are not seeing the case, don't issue. Sir, can I give medical certificate for 3 months, 4 months? No. Give only maximum 2 weeks. Maximum 2 weeks. After 2 weeks, ask them to come, re-examine, and again issue for 2 weeks. You are not a god to issue for 3 months. Don't issue for 6 months. There are at least 4 to 5 cases which is in Karnataka High Court where I had to tell that we don't issue for 6 months, and I have not issued for 6 months. Nearly maybe around 10 years back, by mistake we had issued. We have not issued. So issue only for 2 weeks and then re-examine after 2 weeks. Go on re-examining n number of times. You have to document that after 2 weeks, I have examining him now, continues to be worsened or he has not come back to the original. So for extending the certificate, please re-examination is required. Whenever you issue a certificate, please take a request letter, especially medical legal issues. Suppose he is going to present it in the court, or you are suspecting there will be a medical legal issue, ask them to give a request in his own handwriting, maybe in Kannada, whatever, let him sign it and give it. If you want, ask him to submit a Aadhaar card also, a copy of it. And before issuing the certificate, identify the patient medical certificate, medical records has to happen. Because if you don't know the patient very well, sometimes you make a mistake. In one of the case which I made a grave mistake in Nimans was a patient was admitted from the court. His name was Mahesh something. Mahesh, example I'm giving you, Mahesh, I have admitted him. I saw him. He was from Kolar prison. I've examined and I sent him. And within next 15 days, there was a letter from the court telling that please issue a certificate, medical records of Mahesh. I thought it is from Kolar. I issued the medical records of Mahesh from Kolar, but unfortunately, I forgot the court. Someone was from Chikmagalur, and the Mahesh is from another prison, Chikmagalur prison. Later, it was a big halla gulla that I have to go and clarify in the court of law. This Mahesh is from Kolar, that Mahesh is different, and invariably, this kind of goof up should not happen. And it was a very difficult scenario explaining the court because it was a clear mistake from me. So you need to identify the patient, medical records. If many a time the police will come and ask you, please give a certificate to Mr. Rajesh. You have seen him. Now you need to know who is this Rajesh, what is his address, what is his father's name, whether he has a medical record, whether you have kept the hospital records, hospital name, hospital number if it is there. So please take those. And whenever you are issuing a certificate to somebody, maybe to the principal, you write there. Don't write whomever it is concerned. So it looks very, very unofficial. Make it very clear. If the person says that I'm issuing this certificate to college, write to the principal. If he says bank, write to the bank manager. It is not a certificate, Janta certificate you're giving to distribute to anybody. To whomever so concerned, please don't do that. Ask him where he is submitting. And name them and send it. It becomes very clear for what purpose it is given. Issue the medical certificate on the day when you are examining. Never backdate the certificate. Imagine if a person comes and says, sir, you have seen me around 6 months back. I want a certificate 6 months back. Don't give it for the past date. You say, today you have come. I'll open the medical record. I'll see, yes, I have seen him 8 months back. And I would have told him, take this medicine, you'll be all right. Now he says, sir, I have seen you 6 months back. 6 months I am on bed rest. Give me a certificate now. Don't fall for the trap. You say, I have seen you 6 months back and I never told you for 6 months bed rest. And you say on that day, then you have to issue a certificate today telling that 6 months back he had come for OPD basis. I have seen him once. Medication was given. And today's date he will be issuing. And preferably issue your certificate when you are on OPD days. Don't issue on Sundays. It becomes very difficult to explain the court, why did you issue on Sunday? Is there any personal nexus between the patient and you? Not being on duty, you are giving. Suppose you are on OPD duty, no problem on Sunday, fine. Or you are on a duty on Sunday, you can issue. better to follow the timing where justify the certificate with factual information and logical explanation. So severity of illness, disability, limitation, all those things can be explained. By many a time the doctor will ask, sir, can I write this certificate is not for legal purpose? That kind of wording will bring down your anxiety, but it can be, the court will not accept those kind of words. The court will say, yes, you have seen, to be taken as an evidence or not, it is the court's decision. You are not intended for legal purpose. All those things is useless. The legal person, whoever sees, will laugh at that. So don't put that prints. It is not intended for legal purpose. And many a time doctor will go and say, sir, it is written here, not for legal purpose. Nobody will accept that. So please do make diagnosis or provisional diagnosis when you are writing, and those diagnoses should be acceptable by everybody. Don't write some diagnosis which was around 40 years old diagnosis. Please don't do that. Update yourself, and it is available in the latest. Never give a contradictory medical certificate for a patient who was seen by somebody else. Imagine Dr. Jai Prasad has seen one case. I should not, unless I am very sure, don't issue contradictory certificate. Imagine Dr. Jayaprasad had seen around 3 months back for typhoid. Today I am seeing and issuing for tuberculosis. The, the patient may say that, see, Dr. Jayaprakash treated me for typhoid and now Dr. Suresh has given tuberculosis. Dr. Jayaprakash Prasad was wrong. Those kind of contradictory certificate, be very careful. Is there any such kind of contradict? Is there? Nothing will happen, but invariably it is a going to the consumer forum, or those both certificate will be produced in the medical council. Avoid abbreviations in the certificate, and especially for fitness certificate, please follow the procedure of your hospital. Keep a copy of the medical certificate. Issue medical certificate only to the patient, not to anybody else. Do not cross your specialty. If you are a gynecologist, don't issue certificate for orthopedics. If I'm a psychiatrist, I should not give a certificate for something else. Unless nobody is there and you are the duty person, you can write, I am on duty on this date. In the emergency, I'm issuing on that places, then it is acceptable. Issue the certificate for the period you are examining him. Don't examine for something else which you have not done. Do not tamper with the medical certificate. Do not overwrite. To conclude, my dear friends, medical certificate is a legal document and it can be called for any time for the examination, cross-examination. Follow the principles of issuing the medical certificate. Know the ethical and legal issues in certificate. Please do not issue certificate beyond your specialty. If you are doing it, be careful, and also issue certificate when you are in OPD and for the duration when you have examined, not anybody else. And don't issue for 2 months, 3 months, and never backdate the certificate. If you are issuing certificate today, write today's signature. Don't tell that I have examined in January. Don't issue certificate in January. You say I have examined in January, but today's date you have to put. With this, I'll open for the questions, and this is the QR code for the YouTube videos if you want to know. Now, people, if you had put questions on the chat box, I'll be happy to answer. Dr. Madhusudan?
Yeah, I'm online.
Yes, sir. Any
Yeah.
questions are there in the chat box?
Yeah, definitely. I'll just go through each one of them. I'm just making a point of it.
Yes, sir.
Yeah, Dr. Harsha Jivi has asked, I'll just go. Can we attach a photo of the patient and Aadhaar to the certificate? Can we take the patient's signature on certificate?
Yes, sir. Please. NMC and the MCI says that take a signature of the patient on the patient certificate. That is how it is clearly written there. On the top, patient signature or thumb impression is there. Then we don't follow that actually. Nowadays, you can take the Aadhaar number, or else if you are able to, basically you need to identify the patient. That's what the medical certificate. Yes, but after 5 years, if you are unable to recognize him, it becomes a big headache. Either your memory has declined or you have forgotten. For that purpose, having Aadhaar number, photo ID, no problem. It will be very helpful. Please do that. It will be, especially if you are from forensic medicine or you are in a casualty, asking for Aadhaar photocopy, it can be doable. Any photo ID issued by the government.
Thank you. Mahesh Hemadri, at what level of cognitive impairment of elderly makes eligible for writing will? for his children?
Okay, that cognitive ability, I would rather put it in this way. If the person is moderate and above, you will not be able to give the certificate, issue the testamentary capacity. See, testamentary capacity has different variations. One is cognitive capability. If he is unable to tell, imagine testamentary capacity is for every person here who are there here, it is a capacity to make a valid will. The valid will means, first and the foremost is whether what is the illness he is suffering, whether that illness comes in the way of making his decision. What is the decision now? Decision is regarding the property. How much movable property has, how much immovable property has, is there. He is able to name them. 1, 2, 3, 4, 5. This property, what is the approximate cost? What is the property of this immobile property? What is the cost? How he is dividing it? The next. Whether the division is logically explainable. Whether there is any delusions telling that yes, my son is trying to kill me, or delusion of persecution is there, then although his cognitive function is there, since there is a delusion, that becomes invalid. That testamentary capacity is not there. Invariably, cognitive decline, mild, no. Moderate, yes. That means in HMSC, out of 31, if he follows below the 21, 22, you have to be very careful. That time you can't give a testamentary capacity that he is able to make a valid will. That is not possible. Invariably moderate and below, invariably we don't give. But at the same time, although he may score 28, but he does not know the why he is dividing, whether he is unable to explain logically. And you need to ask the person, in the absence of all family member, is there any coercion? Imagine if the son is standing in front of him and he's looking at his father in big eyes, then you need to understand that he's threatening his father. So that coercion, in the absence of everybody, if there is no coercion, then only you will issue a certificate, STS, testamentary capacity. Otherwise, better is admit the person, examine over a period of 2 to 3 days, then issuing the testamentary capacity. Invariably, what happens in dementia, it is not a steady decline. Fluctuating decline occurs in capacity. Sometimes what happens is, today morning the HMSC score will be out of 31, maybe 27. In the evening it may worsen suddenly to 20. So that fluctuating sensorium becomes a big issue, especially a person who has dementia, maybe with superimposed delirium, it becomes a difficult. And also, even if he doesn't have delirium, the cognitive function may not be 100% same every time in the elderly population because of various reasons. It fluctuates. So I have to be very, very careful. And especially in NIMANS, when we issue this testamentary capacity, either it may be for psychosis or maybe for delusion, bipolar affective disorder, we admit, observe over a period of maybe 1 week or maybe 2, 3 days or 4 days. And then we will say, yes, we are able to see the cognitive functioning over a period of 7 days. It is statically or it is almost stable. Then we issue the certificate, and that goes into the court, and we request the family to execute the will maybe in another 2, 3 days. Not that you have issued a certificate now and they execute a will after 1 month, it becomes invalid, because in that 1 month the things may change.
Yeah,
So
so
next
thank you.
question.
One more. For pediatric patient, can we give to attendant or only to parents?
Best is to the parents, I would rather say. But if there is no parents, and if there is only for school purpose, that is the reason I said don't write to whomever so concerned. And it is for the school, you ask who is the principal, and then you can directly post if you think there is something they will be misusing it. Or else you can, it's imagine 1 day leave. For that, you should not be worried. You can hand over to the guardian. But legally speaking, parents would be the best person to hand over the certificate to them.
Okay, thank you. And one more, Dr. Manjunath from IM Holalkere. Following road accident, patient is drowsy. Different name was given. After referral, feedback will be different name. So what should we do?
Sorry, I could not get the question, sir.
So he said, following road accident, patient is drowsy. His name was in a different name. He was admitted. After referral, feedback will be different name as
Okay.
given by the father. So there is a discrepancy in the name at the time of admission and then referrals.
Okay. So this is very common in demands. The patient is brought with an accident, he is unconscious. We admit them as unknown many a time.
Unknown.
Or
Yeah.
else, that is one scenario I can give you. Second scenario I can see is the family will bring a person who is ill. They may call Madhusudan as Madhu. Madhusudan Karignur they will not write. They will write Madhu, and it is registered as Madhu now. And now they will say, now we have to submit this, sir, for Madhusudan Karignur is a medical officer, and he is what is that? President of so and so association. For this purpose, we need to have. Then what we will do is we will ask them to execute an affidavit telling that Madhu is same as Madhusudan Karignur, and this is his ID, this is this reason, and we have issued this. That affidavit by notary will be sufficient to change the name in the name. But if it is markedly changed, it is very here and there we can do it. Otherwise, unknown person, the new name can be given. After that, you can write there. After 3 days, the person is able to regain his consciousness, and he told his name like this, and this is his full name. Or else many a time the pet name will be given during the registration. For changing the name, you have to get the notary affidavit sworn, and then that will be the name given. That is how the procedure is done in Nimans. That is the fair process. Even changing the name in the court, they have to go declare that and then put the name in the paper, and then finally it is the affidavit which will make it as a new name. So that is how the name changes occurs.
Yes, sir. Thank you. And one more question. I work in an industry as a medical officer. Usually we get requests for change of job citing medical issues. We do ask for specialist opinions, but HR will again ask for opinion on the medical certificate. It is usually in mails. Are we justified in giving opinion? Is it valid in the court of law?
Okay, let me put it in a very clear. Again, this is very common in Nimans. We get this certificate from BSF, paramilitary forces, railway, KSRTC. Either they may be using alcohol, or maybe he does not want to go in an excellent area. He has been posted from BSF, or he says, railway, sir, I can't do what is that pilot in the locomotive pilot. I can't be there, sir. It is very heat. Give me a desk job. Or even the KSRTC driver will say, I can't do this. Give me a desk job. What is the question? How we deal that? Invariably, in Nimans, what we do is we ask for a request letter from the employer, whoever it is. If it is KSRTC, his immediate employer manager has to issue a certificate telling that please give us a medical fitness certificate to join back to duty, or is he unfit? That certificate will be taken, the person will be admitted, observed over a period of maybe 1 week, all possible investigation is done, a medical board will be done. During that medical board, the decision will be taken whether he is fit to go back to duty. Is fit, he is going back to duty, no change in the job. No, sir, he is unfit. Next, the unfit will be two types, temporary or permanent. If it is a permanent unfitness, he will be removed from the job. Either it can be VRS, or else if he's in a private, he will be removed. No, sir, it is temporary. Then you say he will be given 2 months, what we call it as a leave, and he has to come for monthly follow-up. After 2 months or 3 months, we will redo the medical board. At that time, we will assess whether he has improved. Similarly, we do three times the fitness. In spite of 3 times the fitness, he continues to be unfit. Then we issue a permanent unfitness certificate. We will never say change the job. We will never do that. He can be given desk job on humanitarian basis. No. Our examination should be logically explainable. Imagine for a person who had one of the BSNL only, one of the driver had narcolepsy, and we had to issue a certificate. He had narcolepsy, he is a driver, and he is not safe. We had given medicine, and in spite of that, he continues to have. He has to be changed from this job. We are not telling this job or what job they want to give. This job cannot be doable. So the authorities will decide whether they will keep him as a what we call it as a driver, or he has been taken as a driver. Then they will remove from the job, or they may say, okay, considering that you were working here for past 8 years, they may say, okay, we will be giving the desk job. That is their authorities' decision. Don't give that kind of certificate on humanitarian basis. Please give him this job. No. Diagnosis, whether he's fit, unfit, treatable, not treatable, permanent or temporary. On that only we have to issue, and later they will decide whether they want to give what kind of job or they will send him home. It is based upon that. We should not enter into that telling that please give him a desk job. He can't do that. Only say that this job, examine. Another example I can give you is a person who had epilepsy, is on valproate and carbamazepine. he was working on a heavy machine. Then we have to say on this medication, night duty, if he does, there is a possibility there will be an accident. And he has to be on this medicine for 5 years. We request the authorities to keep an eye on this issue. How they will do it, it is left to them. You can't say that don't give him machine job because he has been hired as a machine operator. And if you say that give him a desk job, that becomes wrong. It is the authorities' decision whether they will give that job or send him home or they will hire somebody else. It is left to their discretion, their discretion. So our job is illness, whether it is treatable, not treatable, unfit or fit. That is our answer. That is how we decide here in NIMANS.
Yes, sir. Thank you. And this question is related to the death certificate issuance. This happens usually at the rural setup and in our periphery, where without seeing an elderly sick bedridden patient, if a relative requests for death certificate, what should be the advice?
My advice is if you are not examined, don't give certificate
Yes, absolutely right.
because you don't know the cause of death.
Yeah,
How will you know the cause of death? Imagine there is a foul play.
yeah,
So invariably clinical autopsy has to be done, and then only it will happen. But anyhow, many our doctors are very what we call it as
generous.
generous. They will issue certificate telling, sir, I know the family. It is they are taking risk. Let me be very
Yeah,
clear. If you are not examined, you are not going to issue the certificate. This is my legal opinion. Let's
yeah.
be very clear. Unless you know the diagnosis, don't. I would rather put it in that way.
Yeah, yeah. A lot of things happens
Doctor.
on the trust in the
Yeah.
periphery and our rural setup because we will be knowing the family for the years and without we may not expect any foul play. So that way it goes. And as of now, we are not supposed to issue the death certificate. We can intimate the authorities. There is a definite portal, e-Janma and death and birth certificate, wherein we need to take the details from the attenders. Then we have to enter the concerned municipality will issue the death certificate.
Yes, sir.
Even death and birth certificate also earlier, as the practice was going on, the hospitals and doctors used to give the certificates. Now it is not the point now. I mean, that is not the practice now. So we need to
Yes,
inform
sir.
the concerned authorities. The authorities will issue the certificates.
Yes, yes, sir.
Yes, sir.
Dr. Suresh Badavanте. Hello.
Yeah,
Hello.
yeah.
Namaskara, sir. Namaskara. Yes.
Namaskara. Regarding nowadays, we are getting this one birth certificates. They'll be delivered 15, 20 years back in the one hospital. Afterwards, they come for the birth certificate to give. 15, 20 years back, this is here, my daughter, my wife has delivered here only. Give the certificate like that. They are coming now.
We should not entertain that, sir, because we don't know and we are certifying something else.
Yeah.
Imagine, I'll give an example. There are many refugees coming from various Bangladesh, and you are issuing a certificate for them, telling that they are born here. And tomorrow something goes wrong, it will be a big headache for us. Without, they may say 100 things. If you don't remember, say, I don't know. I can't issue certificate.
If the in our records, if it is there, can you give it as a duplicate or as per our records we have given?
Extract, yes, sir. Extract can be given. If they are very clear, it is the person who is asking for what purpose, and then you can issue the extract. That is usually given for, especially this occurs in the POXO case. The child may be accused of child sexual abuse. He is maybe 17. Then the police will say, no, no, he's 18. Then the police will go to the school, or maybe either the SSLC certificate will be used, or maybe birth certificate extract will be taken by the police. Then they usually issue the certificate telling that, yes, this is the extract of Mr. So-and-so, son of so-and-so baby, and born on this date, this time. This is they give. Nowadays, the birth certificate has been invariably given the mother's name, and mother Aadhaar card has been linked. Nowadays, slowly they are doing it. Otherwise, yes, that can be doable, sir. But suddenly there is nothing is there, and they say that, sir, you had seen earlier around 30 years back, 20 years back, you are my doctor, and this is the child. Now he is 21 years. Please issue a certificate. Please don't do that. And if you issue a certificate, who knows? He has been accused of under POXO case, and he's already abused a child, maybe 14-year-old, and your certificate maybe says, see, Dr. Suresh has issued, he's still 17 years old. then you will be pulled into the unnecessary legal battle.
Yeah, definitely. And
Last
even
week,
we need to keep all the even births, especially the obstetrics. We
Yes.
have to keep the documents.
yeah.
Yeah, we need to keep at least 15 to 20 years, because earlier there was no practice of these Aadhaar card linkage,
Yes,
and
sir.
we used to keep only the hard copies with us, the birth certificate, I mean, even the entry of the birth, and
Yes.
the document that was submitted to the concerned authorities. You take a signature, seal, then keep the document. And my practice is I always keep one set of Xerox copy of that documents in a locker. If the original is missing, definitely I'll have a one more backup,
Yes, sir.
and we
And
can
invariably, copy will
digitalize.
go to the sir. Copy will go to the corporation invariably in the
Yeah, yeah, yeah.
metropolitan cities, so they will have a copy of it actually.
We have a very peculiar problems here, because when the girls get married to the house, they change the name. That is a
Sir,
difficult
this
part,
is
where they when they come to delivery for their in-laws house, usually they will be sent back to their mother's place. The father in, I mean, their in-laws, they would have kept one more name. Usually it is a conflict. They enter that name again. They come after 5 years to change the name. It is all things that
Madhusudan
happens.
sir, 5 years we see day in and day out. As you said, no, once they get married, they have a different name, and the BPL card has a different name, mother's name, family's name
Yeah,
will be there. So it becomes
yeah.
very difficult, and many a time during admission they don't look into those aspects. They just register name, and it becomes a big issue. Yes, I agree, but invariably the affidavit is the only way we can say that they have taking the affidavit and the notary, when they sign it, it is taking oath in front of the law. So invariably, something they have manipulated, they will be held responsible. But you have to case by case basis, we need to take decision on that issue, sir.
Here, peripherally, usually we come across the issuance of medical certificate for absence of students for 30 days, 60 days. So they come beg, and definitely we don't issue those things, as technically we are not supposed to issue, because we don't know what has happened to him. Number one. Number uh, two, the one more question is coming. I'm just go through. Somebody has asked.
Okay, this is Raman sir as request. Can we give a certificate or a medical record if the patient is traveling to a foreign country with a certificate of the
Yeah,
need of regular medication? Yes, sir.
yeah.
Dr. Raman sir, is definitely we issue based upon the country. Suppose somebody is carrying medication to UK, it is only for 60 days. US earlier psychotropic medication 2 weeks, sorry, 2 months. More than that, it will be very difficult. Don't issue spasmoproxine to Islamic countries because it is a punishable offense for them. If somebody is carrying even the commonest drug, painkiller, along with spasmoproxine, the other one is there, which has been, they are caught, they will be jailed. So we have to explain the family, don't carry these drugs to those country. That is one thing is very clear. I'm forgetting the name. Which is the painkiller commonly misused, sir? Uh,
Plasmaproxy sir.
One is
Acetaminophen,
spasmoproxine,
even
another one, sir.
Diclofenac
uh,
series.
Sir?
not diclofenac, sir. Idu
Tramadol and
Tramadol,
tramadol.
tramadol, sir, tramadol.
Tramadol.
Yes, tramadol,
Yeah,
tramadol. So those are
contramal
the
usually.
drugs. Yes, especially in Islamic country, it is a punishable offense to carry the drug. Even in spite of they have a prescription, they will not allow.
Prescription also.
And even tapentadol is one which is been nowadays used as a IV injection. So these are the drugs, especially those drugs, and especially don't give those drugs especially. Otherwise, if they are going to Western country, tell them these are all banned drugs there. Please be careful. Otherwise, like antidepressant, it is 2 months. Yeah, 60 days is the, earlier it was 90 days. They have brought down to 2 months at this point of time. And please send a valid medical certificate, or else even the medical record along with the prescription they should have.
Sir, what is your take on the students will come for
Mm.
certification for them to join the school, that is fitness, or as we said, the number one. Number two, usually students will come for certification to attend NCC camps.
Okay. So I'll give you one example. This happened in Kota. Kota is Rajasthan, where a lot of death by suicide occurring with the students. So the district administration decided, telling that many of them said, no, these kids have depression or earlier mental illness, substance use there. So before they need to undergo regular checkups with the doctor. So what happened was it became again one more industry to make certificate, and every before admission into any Kota tuitions or maybe in the PG, they demanded certificate. Tell that my son doesn't suffer from any mental illness or any drug abuse. So this becomes a big headache actually, but otherwise not required. But invariably, many of these places, they ask for normalcy certificate. If there is a preformed format is there under NCC certificate that this person does not suffer from any illness, that's fine. But if they have epilepsy, many a time they hide this. This is a big headache.
Very difficult.
Unless we do EEG, unless we do certain tests, it will be very difficult to know. Uh, these are all very dicey situation. Invariably, earlier we had something called as family physician. They knew the whole family for many years. They will issue certificate. In nowadays, suddenly one day they come in front of us and say that please issue a certificate. 2 days back also happened with me. Somebody was supposed to join engineering college and they said please issue medical certificate in our apartment. And then I said I have not examined you. I don't know who are you. I can't issue. Then he said, sir, I'm in this tower block. So fine, excellent. You need to go to your family doctor. They will be able to help you. Otherwise, that there is one small signature, sir. Then I said, it is a small signature, but it can cost my license. So I have to explain
Yeah.
them and send them.
It's not as easy as the earlier days to give the
Yes, sir.
certification. Yeah, we need to weigh each and every word, every certificate. We need to take it seriously, sir. Any other questions? I think
Good
we can
evening, sir.
unmute people.
Good evening, sir.
Surya,
Dr. Suraj here. We come across many patients coming to the ER, broad dead, sir. In that situation, they insist us to give death certificate. We will be not knowing the exact cause of the death. So what we should issue, sir?
Sir, you have to tell the family, if you have good number of people around you, tell the family it has to be sent for postmortem. Otherwise,
Okay.
we will not be able to know the cause of death. Immediately, if you ask me in Nimans, what we do is we'll say that death has occurred. We will inform the police. Police will take the dead body. They will submit for postmortem. Then only we'll be able to tell death certificate without knowing the cause. That will be after the postmortem, the report will come. That is the way the exact legal procedure. Otherwise, you don't know the cause. We don't know. Best is not to enter into this discussion. Tell them, yes, we take the body inside and say, immediately intimate the police, nearest police station. They will come and they say, okay, sir, bought by dead is there. Please register MLC and get the body for medical legal autopsy. And finally, the certificate will be issued by them through the postmortem report. So that is how it is done. Otherwise, if you issue a certificate, invariably they will come and cry. And many a time our doctors also get yield to this pressure. I think we should not get into this. One more interesting question I think Dr. Pooja has asked: if patient is in jail and the family member is asking for a certificate of treatment, should we give them or not? Sometimes they also ask for old records of the patient. Invariably, it is the patient who needs to ask the records, not the family members. If there is authorization letter, fine, or else ask them to go to the court. Through the court, we will submit to the court. That is the best.
yes, sir. Any other questions?
Sir, they asked for the certificate to perform last rites. How to proceed?
Sir, I could not understand, sir. If the
Patient is dead at home,
okay,
relatives come to the hospital and ask for their certificate to perform the last rites.
no, sir, I will not issue.
Cremation.
No, sir, no.
Yeah, Suresh here. Just
Yes,
one
sir.
week back, one fellow is known to me. He's a close relative of mine, and his one of his relative expired in one function, cardiac arrest. He was taken immediately to the nearby hospital. They told that it is already brought dead. They were kept there and taken the body to the home, and everything they was finished. After 8 days of that one, he has come to me to give the death certificate.
Sir, without knowing the cause of death, how we can be certified?
Yeah. I told nobody, no one is going to give you. You get the certificate from the panchayat or municipality.
Okay, sir, I think the Dr. Vinay Shetty has asked for film producer case, the first case Vignet. So that was a very difficult scenario where what to be done. So the first and the foremost, we had to explain him, telling that this is a 3-year-old case. I had gone for an OPD basis, and we had told him, telling that the MCI does not mandates for OPD basis certificate. So I have not kept anything. It is with the patient. So that was the first defense we asked to take him. Otherwise, and then the second defense, the good that lawyer did not raise. You need to have a copy of that medical certificate, which the MCI clearly says that. But that lawyer did not ask that question. So if you had asked question, you should have been say, sorry, I don't have that, or I lost it, I shifted from one place to another. So it is a human error. Ask for that plea to the court, telling that yes, there is a mistake from my side. I have lost that certificate. I have not kept that certificate. Second, third one, please explain the certificate. To explain the certificate, I can see these are the examination I have done. I had asked for these examination ABCD, and they are not done, and they are not called me back. So I am unable to give any valid conclusion. Full stop. Don't don't extrapolate your information. You have examined ABCD, stick to that ABCD only. Don't say because of ABCD, this can be EFGH or ZXY. Don't extrapolate that. This is, in that case, sir, on that day, he had a hard of hearing, had to repeat the question, he had attention difficulties, he had recent memory deficit. This is what is my observation. I have not examined for the purpose of the testamentary capacity. My examination, whether his signature will hold good in the bank account, for that I have issued the certificate. This certificate, can it be used? I am sorry, sir, I will not be able to give any opinion on that matter. The court will be very happy because you are giving a genuine opinion, telling that I've examined for this purpose, they called for this, I've done that much only. And with that certificate, what they have, I have done this much. Luckily, the court was happy, did not penalize, considering that MCI told that OPD basis there is no requirement of documents. It is only for the IPD the requirement of document, and there is IPD documents what has to be kept is clearly written in the MCI document. In that way, we were able to help the doctor in defending the case. Unless somebody, one of the family member, if they had challenged it in the state medical council, it would have been very difficult, telling that this doctor has given a certificate in a malified intention, and this is not false, this is not a true certificate. It will be very difficult to defend because you don't have any medical records.
Good evening, sir. Similarly, the people will come to the hospital saying that instead of signature, like 70 years, 80 years old, like they want to give thumb impression in the banks, like 70 years, 80 years. So they'll be having tremors. So they're not able to send like as previously. It will be mismatching. So they will ask like thumb impression can be certified from the doctor and it can be considered like. Can we give that?
Yes, sir. Yes. Sir, it is done in demands, especially Parkinsonism. Many of them senior citizens or early onset Parkinsonism at the age of 55, 60. They are operating bank account. If what we do is we will open a file in their name, examine. I'll give an example. Like Dr. Ashwin is there. Dr. Ashwin has this essential tremors or maybe early Parkinsonism. He is unable to sign, and his signature has changed. The bank checks are getting bounced. Invariably, we will open a Dr. Ashwin's name as in the Aadhaar name, or else the name what he is there, and that we will open a file, examine him, and we will issue there is a bank format certificate is there. That certificate will be brought, and we will issue this, telling that this signature has changed. Hence, instead of his signature, this has to be done. It may be thumb impression can be validated. So that will be, they will accept it, especially for bank accounts, sir.
Okay, sir. Thank you, sir.
So before making any will, okay, is it a doctor permission? Generally they will go to a lawyer and they'll make the will. So is there any medical certificate required for preparing the will?
Sir, by default, everybody has capacity. That is the law says. Any contract is done, the law believes everybody has capacity to make a valid will or enter into contract. If there is a chance of past history of mental illness, that is a question can be raised. Or else if somebody says that this is the not a valid contract, then only we need to get it examined. Otherwise, every day there are many wills are executed. Nobody will ask for mental certificate unless there is a past history of mental illness, or else currently he is mentally ill, or else he is having dementia. Somebody is going to challenge then only. If somebody is challenging, that person has to produce the certificate telling that this person has mental illness, hence it is not valid. Then only it will be questioned. Otherwise, by default, everybody has capacity, everybody can execute a will, unless somebody raises a question, prima facie, telling that this person has this mental illness, this is the earlier prescription. So then to protect for that kind of question, you imagine if there is a schizophrenia patient who is doing well now, he is under my treatment. If he is going to execute a will, tomorrow they will come in the morning, I'll examine him and I'll say currently he's on medication, doing well, and I have examined with regard to how much property, for what property is executing will, what is the logical explanation. He does not have any delusions and hallucination. His HMS score is this much and there is no coercion. I have examined in the absence of any family member and he continues to hold this good and he is fit to execute will. If that I give that certificate and he executes the will, nobody can challenge because I have examined his earlier schizophrenia. Currently, he is in a lucid period and he is doing well, he is asymptomatic. That certificate will be honored. Otherwise, if there is no history, family history of mental illness, not to ask for examination. It becomes a scenario. Why did you get examined for psychiatry? Unnecessarily, we should not do. That is my response, sir.
Sir, there is one more question where uh, I'll just put through. There is a discrepancy in my network.
Yes, sir.
So if you can read the last question, can certification be issued on video conference or telemedicine
Okay, Dr.
consultation?
Akanksha. Okay, yes, sir. Sir, this is a very common question because I'm adding telemedicine. See, telemedicine consultation is equivalent to in-person consultation. Let me be very clear. And please, the way you follow the procedure in outpatient, follow the same procedure. It has the same sanctity as a in-person consultation. Legally, if you look at the telemedicine guideline, TPG guideline 2020, it says that all laws applicable in-person consultation is applicable even in telemedicine. Hence, you can issue. Don't issue for 2 months, 6 months. Don't do that. As mentioned, every 2 weeks you can do that. So be very careful. But however, this has been one of the biggest challenge. Currently, the National Medical Commission says that there is something called as NMR, National Medical Registration, one number, and state medical licensing. Every state will have a license now. So that means I'm having a national registration on NMR. If I want to practice in Karnataka, so Karnataka license I have to take. If I want to practice in Tamil Nadu license I have to take. So multiple license, one registration. That is how the current NMC comes into picture. But now imagine if I have examined a patient in Kerala medical council issued telling that don't examine the patient if he is not in your jurisdiction. That is the wording the state medical council said. Sir, is it valid? Yes, of course it is valid. Simple reason is under the constitution, health is a state subject. State will make law regarding that. So in that regard, although the NMC's telemedicine practice guideline says that you can practice in any part of the country. That is the telemedicine guideline under the MCI ethics regulation under the appendix 5 it has been notified. NMC Act clearly says that you will have registration and under the license to practice regulation, it says you have to have a separate license for state. So this is a very catch 222 situation question has been raised. At this point of time, if you ask me, it is valid, but it can be challenged in the court of law. You are in Karnataka and you don't have license to practice in West Bengal. Can you issue a certificate? This can be challenged not only under NMC. Clinical Establishment Act says that if you are practicing in your Karnataka, if you are a private practitioner, you have to take a private clinical establishment certificate or the establishment that you have to notify under that. So then Again, in West Bengal, there is a similar law. Again, that becomes a problematic. At this point of time, we don't have clear answer, madam, but that's a very good question if you ask me. But telemedicine guideline says that you can practice in any part of the country. But legally, if you go into the minor aspect of the legal nuances under NMC and license to practice regulation, and also Clinical Establishment Act, there is a discrepancy which we need to settle this by discussion, but there is a time to that. Otherwise, you can issue the certificate.
Yeah, thank you, sir. As far as my knowledge goes, I
Yes,
think
sir.
there is a lot of changes needs to happen, wherein in the borders areas between the two states, it is a matter of 1 or 2 kilometers where the practitioners has to practice in the morning in Karnataka, the Maharashtra, Andhra Pradesh, and Karnataka. That way, so it is very difficult to have dual council membership. I think
Sir,
NMC in the coming days needs to act in this
yes,
direction.
sir, that is very clear, sir. Madhusan, sir. Single national medical registration, you will have multiple license. Example, Delhi. The is in
Your voice is not
Gurugram.
heard.
Gurugram is suppose a person who is practicing in Delhi. Do you hear me, sir, now? Yeah,
We can
yeah.
hear.
The best example is either you can take even Punjab also, especially Chandigarh. On one side there is Haryana, other side is Punjab, and another one is Chandigarh itself is a union territory. Where should they take license? This is a question. So single registration, multiple license. Imagine if I am in Delhi, I want to practice in Noida, which falls in UP. I will take license to practice. One is single registration is there, NMR lifetime once. License to practice in UP, license to practice in Delhi, license to practice if I want to go to Gurugram, license to practice in Gurugram. Monthly once I visit to Rishikesh, license to practice in Uttarakhand. So you have to pay, I think, around 3,000 or 4,000 to license to practice in multiple places. That is the current clear understanding about NMC, because the simple reason is state has the health is a state subject. The state will decide who will practice in my state. Example one again I'll give you. Chhattisgarh has given permission to practice who have passed 3-year MBBS course, which was long back. Supreme Court held null and void, but still they are practicing. So Chhattisgarh can decide who can practice that medicine in that state. So state can make the under the constitution. So in that regard, the state license becomes valid, and so state will be able to make the law with regard to that.
Yeah, there is an ambiguity in Karnataka Medical Council also now. It is
Mhm.
also not clear in between the border practice. I think in the coming days it will be solved, I feel. Yeah, I
Okay,
think
sir.
it is 10:30 now. Shall we
Sir,
make it?
Dr. Jaspal Singh wants to say something.
yes, sir.
Dr. Jaspal Singh, please go ahead, sir. You can
I
unmute.
just have a very simple question, sir. I'm
Yes,
a
sir.
surgeon, and while we operate some of our teenager boys who are school going, college people, or some employees who are working in government office or like KSRTC, there is a tendency of these patients to ask us for a post surgery certificate wherein they want us to give them some good bed rest later on. Is there any timeline or restriction, because school matters, college matters are there wherein we have to restrict these certificates? They keep on asking and compelling us, saying that, sir, he is not still comfortable, so we'd like him to be given another 15 days. Are there any guidelines, sir, that we
Sir,
can
it is,
issue?
sir, Jaspal, sir, if I'm in your position, I have operated somebody and I want to see him after 1 week. I'll say I will issue for 1 week. After 1 week, after examination, if it is pus is there, he has fever, I will extend another 1 week. So, see, if in the court of law, if it is challenged, you can say, sir, it is not that I have given blanket for 1 month. First, I examined for 2 weeks, or maximum, I would rather say 2 weeks. Or else, sir, I have operated on 15th of June. I have examined again on 23rd of June. I have extended for 1 week. And again, he entered into complication 1 more week. The court will be very happy. Dr. Jaspal, sir, has made multiple examination and extended. Unfortunately, what happens in the court of law is we have seen doctors issuing certificate for 3 months and he has not examined for 3 months. Then the veracity of that certificate is questioned in the uh, court of law. If the same doctor has issued over a period of 3 months, examining at least 6 to 7 times, the court will be very happy. He has examined so many times and multiple certificates have been issued. So that means the doctor is logically is explaining. Every time when you are issuing a certificate extension, you would have written why I am extending. That logical explanation is there, then it will be fine. Why, sir, this logical explanation? Simple, sir. Jashpal, sir, if you have done this and you have maintained the medical record, and by chance tomorrow somebody challenges it, and it goes to Dr. Satyanarayan Rao, these medical record, and he goes through that. Oh, Dr. Jaspal has written on this day I have seen, and again on 7th day he has seen these complication. Okay, I think this is fine. I will also do the same thing. If there is no explanation written, Dr. Satyanarayan will feel that 3 months I will not give for this surgery, and invariably will get into. So it is ultimately it is the documentation. Our own fraternity will evaluate us.
Yes, sir. Yes, sir. Yes, sir.
That logical explanation is there, then anybody sane doctor will support you, sir. I hope I answered your question.
I got your point, sir, but sometimes we are compelled, and especially government officials, for the extension of leave and other things, they keep on asking. I just wanted to know any particular guidelines are also there that we can be
2 weeks, sir.
2 weeks. Thank you.
That is the best, sir.
Thank you very much, sir. Thanks a lot.
Thank you, sir. And I'm really happy there are many people from different part of the country joining IMA Karnataka state program, sir. Thank you.
Even from Nepal
Sir,
also
one
they have
last
joined.
question, sir.
Okay.
Sir, one more alcoholic question, sir. Like,
Please go
patient will be brought with a drunk and drive. Like, patient will not be willing for drawing blood. Like, is it sufficient to give physical examination part, or we should analyze for the blood sample analysis, sir?
Manjunath, sir, this is a very good question. This often occurs very often. Imagine the police has brought, the police will bring a requisition telling that please examine him. Invariably, by the time 99% when the police will bring him, invariably the time would have lapsed, or else he is intoxicated, let me put it in that way, and receive the request. A. B. Take the consent of the person. The person will not give consent, document it. Again, request after 15 minutes. Sir, you need, the police has brought you. Again, he refuses. Don't force yourself. The simple reason is, if you have documented thrice over a period of 15 minutes telling that he is refusing consent, take a third person, whoever is there as a witness, sign it, send it. The police will be happy to carry this, telling that this person did not cooperate for medical examination. We cannot go against somebody's consent. For simple reason is right to life and liberty. There is no life problem here. It is the liberty is the issue. And if he refuses for examination consent, the court will take adversarial position telling that you did not cooperate. That means you are intoxicated. Full stop. That is how it is done, sir. So never force an examination on anybody unless there is a court order. Here it is only the police request, so don't force. Ask for a consent, document. He refused consent. Again, after 15 minutes, again explained he refused consent. If it is 3-4 times, and then the court will take adversarial position, telling that they will say you have intoxicated, full stop. Explain why you did not give consent to doctor.
Okay, sir. Thank you very much. Thank you, sir.
Thank you, Dr. Manju.
Dr. Rajendra Prasad.
Sir, Dr. Arjun has raised a hand. Dr. Arjun, you can unmute and ask question.
Sir, good evening, sir. Sir, I have a small question. I'm a physician practicing in Tumkur. Few times I've encountered patients coming from residential schools, adult only, around or as residential PU colleges, or their friends getting them to the hospitals where they have got seizure, they have got some unconsciousness following some hit. That time, before the some emergency is there, before their parents come, how legally we have to document?
Sir, if it is an
Something to be
emergency,
explained like MRI brain or some immediate procedure to be done, which is quite costly, which cannot be affordable. And even though a guardian would be there from, if at all, if it is a residential school, even they are not 100% bound to whatever happens to the patient. That time we are in the we cannot, we may few times may speak to patient parents, or we may end up in speaking to maximum principal of the institute, or somewhere the people from West Bengal working in some company, company manager will bring the patient. That kind of scenario wherein if you don't have any legal authenticated tender like parents or brothers or own blood relation, if somebody else like manager or guardian or some other hostel warden got the patient, how legally we have to document
Okay.
in that scenario?
Okay, Dr. Arjun, I got your question. You are a private practitioner or a government practitioner, sir?
Private, sir.
Okay, fine. So let me answer to you this. Under emergency situation, you are supposed to do your duty as a doctor. That is what the Permanent Katara versus Union of India 1987 case says, that you need to do all in your power to rescue the life. Okay. What
Okay,
is
sir.
that? What is that? Sir, I am a physician, but he has a head injury. I am not a neurosurgeon. What to be done? So now you will immediately become an MBBS doctor. You need to protect his life. Whatever you have to do as an MBBS doctor, it may be first aid, calling an ambulance, shifting him to the nearest neurosurgeon. It may be government hospital, medical college. That is A. B, sir, it is not an emergency. Okay. In that scenario, you need to talk to that person if he's an adult, if he's able to pay fine, or else, since it is not an emergency, you can refer them to the nearest government medical institution for further needful. If it is an emergency, do all your best in your case. Whatever you have, you will do it, because right to life becomes importance. If you read the Permanent Katara versus Union of India, in that case, it happens like this. A young boy was walking around, one of the car comes and hits him. That fellow has an injury. One of the social worker going on the roadside takes this fellow to a medical hospital. That hospital says this is a legal case, I will not treat him. He goes to the another hospital, they say this is a legal case, we will not get the police complaint first. This 3 hospital occurs and finally he dies. So this social worker becomes very unhappy, writes to the Supreme Court. And if I remember, I think it was Justice Krishna Iyer or somebody who gave a very landmark judgment. In that case, it said there was no law for emergency care. Then they looked into what does the doctor have taken oath. They took the Hippocratic oath. In that we have Hippocrates oath, we have taken a oath, we will protect the life at any cost. That was interpreted that the doctor has taken an ethical oath to protect the life. Then they said in emergency situation, all doctors are legally bound. It was an ethical obligation. They made a legal obligation now. Under emergency situation, you have to do your best. What is that best? You have to become MBBS doctor if it is not in the area of your expertise. Imagine you are not a psychiatrist. Dr. Arjun is a specialist, but there is a psychiatry patient. What to do? You will become an MBBS doctor. What best you can do as MBBS doctor? Arranging an ambulance, sending a referral. Maybe if he requires IV injection, if he has an injury, he will give a TT injection and he will refer him. So that process you have to do. You can't say telling that no, it is head injury, neurosurgery. You don't even tell what is that, do pulse, BP, first aid. If you don't do, then it will be omission of the issue. In this scenario, whenever the patient comes from the hostel, is there emergency? First, I will decide. If it is emergency, you do all your best. And then if you no need to ask anybody's consent. If you ask me, it is an emergency. Under the law, the Constitution gives the power, nobody else. Constitution gives the power to the doctor to go ahead and save the life. Document that the person is unconscious, no family member is there. I am going ahead with this surgery ABCD. Do the surgery. No, sir, the hostel warden is there. He is refusing consent. Don't worry. Tell that yes, this is an emergency and I am the doctor. I feel that it is falls in my area of expertise and this is an emergency situation. I have to operate. This is my ethical and legal obligation. You need not take consent. Go ahead and do. Sir, the money is the issue. The court has said in this one of the case that said first protect the life. Later you can put the case in the court telling that this is the amount I should get it from them. Either they will give or else the state government who is supposed to protect the life of that person, the state government will give. That is Paschim Ket Bangla Samiti versus West Bengal, I think 1992 case. There is a case where the government paid the money for the private hospital.
Thank you very much, sir. This is very, very
Can I
much
ask a question,
informative
sir?
and thank you.
Thank you, Doctor.
Can I ask a question, sir?
Yes,
Left to the chairperson, president and the Madhusudan Karignur. If they allow, please go ahead, sir.
Can I ask a question, sir?
Yeah, please go ahead.
Sir, there is sometimes some false personification. The person identifies and he is not the actual person which is supposed to be. So in that case, what is the legality of the doctor? How he is going to protect himself?
Sir, this is a very good question, sir. Many days it comes. Nowadays, there are many people, especially they come with a different name and they ask for a different certificate later. So best thing is nowadays they are asking for Aadhaar card whenever you are registering. That is almost in every hospital, in the corporate hospital, say please provide a photo ID. That is the best, and photo ID if you are able to keep it. And if he has impersonated, imagine somebody has like they have taken my Aadhaar card and put their photograph and they say I'm Dr. Suresh and they have done the treatment, and tomorrow they are caught, they will be caught because they have done it. So at least we should have a photo ID card of the person and say this is the Aadhaar number. That would be at least reasonable information, sir. But if he is impersonated, you have not done anything, but they have done falsification, then they will be called. If you don't ask any ID and if you treat in emergency case, fine. But in a elective, please ask for a valid ID, sir. That is my advice as a medical legal person.
Okay, sir.
Thank you, Dr. Suresh Badamat. It was a wonderful session, well attended. Over 150 doctors attended from India and our Nepal also.
Nepal also.
Nepal also. It is well attended. Nowadays, we were not seeing that much of attendance in any of the meetings. Thank you very much. Thanks.
All the credit goes to Madhusudan and you, sir. Rajendra Prasad, sir.
Thank you, sir. And thanks to our President, Dr. Chinivalar, and our Kpps Chairman, Dr. Madhusudan Kariganur, and Dr. Shivkumar Kumbar attended, Dr. Harish Delantabittu attended, Dr. Indira, Dr. Anuradha Parmesh, Dr. Jaspal Tahelia, Dr. our Vice President, Dr. Marigowda, and Dr. Suresh Rudrappa, Dr. Jay Prasad. And thank you, sir. Thank you very much. Thank you, sir. It was well attended meeting.
Yes,
Thank
sir.
you. Good
Thank
night,
you.
sir.
Sir,
Thank you, Suresh Badamat, sir.
With your permission, can we?
Please, sir.
Dr. Madhusudan?
Yes, sir.
Can we close the session or?
Yeah, definitely. Thank you, Badamat, sir. You have helped us to understand how something as routinely we issue medical certificate it carries a deep ethical significance and potential legal consequences. Definitely. And I'm sure everyone here will now view medical certification not as a clerical task, but as a professional duty with legal accountability. On behalf of the organizing committee and also IMA Kpps, IMA Karnataka State Branch, thanks once again for sharing your expertise with us. We look forward to much more such enlightening sessions in future. Thank you. We would like to have your services in future. Sir, thank you very much.
Thank you, sir.
Thank you very much. Good night to all.
Good night, sir.
Thank you, sir. Thank you, sir.
Good night to our president.